Hi, everyone. I'm Janvi Joshi, an intern at Gearhart Law. Today, I'm speaking with Ben Schroeder, a patent attorney at our firm, about a new federal circuit decision called REGENXBIO Inc. versus Sarepta Therapeutics. This case looks at whether a genetically engineered host cell used in gene therapy is something that can be patented or whether it's just a product of nature and therefore ineligible for patent protection. The ruling has some pretty important implications for life science companies working with engineered cells, gene therapies, and other biologics who want to protect their inventions. So, Ben, thank you so much for joining me to help explain what this case means for companies thinking about filing patents, especially in the life science space. Is it okay if I ask you a couple questions?
Absolutely.
So, to start with, can you just briefly explain what the REGENXBIO versus Sarepta case was about in pretty simple terms?
There are four main statutes that determine whether or not something is patentable. These statutes are 35 U.S.C. 101, 102, 103, and 112. 101 deals with the utility aspects of whether or not a patent is patentable. 102 deals with the novelty aspects. Basically, invention has to be new in order for it to be patentable. 103 deals with the obviousness standard. Basically, a patent is not patentable if it's obvious over prior art references. 112 deals with a whole slew of different issues, including written description, enablement, best mode, as well as definiteness. Today, the case that we're actually talking about deals with the 101 aspects and whether or not there's utility. What the court was attempting to resolve is whether this was most similar to a Supreme Court case from 1948, from 1980, or from 2013. And I think we can discuss those cases as we go on in the interview.
Yeah, sounds good. And is there anything particular in this case that was the main dispute over whether the patent was valid? I know that the case talked about a couple of details regarding SRP 9001. Just curious as to what was that exactly and why was that so important to this case?
You had alluded to it previously when you actually talked about whether or not something was a product of nature. Generally, a product of nature is not going to be patentable unless you can show that it has some difference from what exists in nature, or you can demonstrate some utility that you made some modifications on whatever your cell line is in order to make it so it's different. It actually presents a different use relative to what it does in nature.
Oh, okay. SRP 9001 is a cell line?
Yeah, it is a cell line. It's a cell line that was actually developed where they were doing modifications of the cell line where they were actually inserting gene sequences from a different line of cells in order to make it easier to do genetic manipulations.
Wow, that's pretty cool. That seems like it has pretty good long-term prospects then for future gene editing and gene therapies.
The Federal Circuit basically found that this was something that actually made it patentable so that it could overcome the utility barrier.
For us non-scientists who are listening, what exactly is a host cell and what exactly were the inventors doing that made this cell particularly different from something found in nature?
A host cell is exactly what it sounds like. It basically is a cell that hosts DNA from a different organism. And in this case, it was a sequence from a different organism that was inserted into its T7 bacterial cell in order to make the genetic manipulations easier.
So that definitely makes it something that's really different and probably increases the prospects of it being patentable.
Absolutely.
Oh, okay. Well, I heard that there was some disagreement with regard to the verdict. Apparently, the lower court said this invention was just a natural phenomenon. Is there a particular reason why they argued for that?
Yeah, the lower court actually felt that it was more similar to a Supreme Court case, which was entitled Funk Brothers from 1948. Basically, the case was the Funk Brothers were actually sued by the Kalo Inoculant Co, who held a patent on a mix of nitrogen-fixing bacteria that helped plant growth. It was known in the field, however, that if you put these nitrogen-fixing bacteria species together, they would inhibit each other so that you wouldn't get good plant growth. However, the Kalo Inoculant Company found two particular nitrogen species that could be combined together and packaged together so you were able to get good plant growth. The Supreme Court, however, invalidated the patent, because they found that all Kalo was doing was using the natural properties of these two nitrogen-fixing bacteria together. And the Supreme Court found that simply mixing them together was insufficient to get over the utility barrier. So the lower court basically cited the Funk Brothers case, in this case, saying that taking two sequences from two different organisms and putting them together is no different than taking two strains of bacteria and mixing them together. right? However, the Federal Circuit really disagreed with that. And they actually felt that this case was more similar to the Diamond versus Chakrabarty case, which was a Supreme Court case in 1980. In this case, the patent holder had done genetic manipulations on bacteria in order for the bacteria to break down oil. Chakrabarty had actually incorporated a genetic sequence in the bacteria that had given them a property that they didn't normally have in nature. And that was the ability to break down oil.
Any key legal ideas that came out of this decision, especially for life science companies that might use natural biological building blocks in their inventions? There's some things to definitely take away from this.
A life science company should be cognizant of these cases and what the standards are in order to get over the utility barrier. One of the things that I would recommend that a life science company is to contact a patent agent or a patent attorney early on in the process to basically put in your application the needed information that will allow you to overcome this utility barrier. And then also when you draft claims, you want to make sure that you draft them in a manner so that your case is more similar to the Chakrabarty case than it is to the Funk Brothers case.
That's honestly really helpful. Anything else that they should keep in mind when working with a patent attorney to protect it, especially after this decision that came into view?
I think the main thing you want to do is you want to make sure that you look for markedly different characteristics for your cell line that you're working on that differs from those that you find in nature.
And I hear that obviously it's always best to get, like you said, patent attorney involved and get the patent counsel involved in early because they can help. I hear it's like first to the patent office gets that kind of privilege. Am I right in assuming that? I think
it's a good idea to engage someone who's familiar with the guidelines in the biotech area.
Thank you so much for sitting down and answering some questions with me, Ben. I really appreciate your time.
Thanks for interviewing me. I really do appreciate it.